All right. Hey, everyone. Alyssa and Nicole here with Blondes Breakdown Real Estate. We're continuing with our series on buyer contingencies and the home buying process. We wanted to follow up with our last video and give you a deeper look into what happens if you've gone through this process and something just didn't go right. What happens next? What's your recourse? So to help us discuss this, we brought on real estate mediator Laura Peterson. She's with Real Estate Risk Management Incorporated. We're super excited to have Laura on this episode today to give some insight on what happens next. So without further ado, welcome, Laura.
Good morning, everyone. How are you?
Good.
Good. So
great.
As we discussed in our last video, during a traditional sale in San Diego, there are certain disclosures that a seller is going to fill out and send to a buyer. The seller is required to fill these out to the best of their knowledge for only the duration of time that they have owned the property. These include the SPQ, the TDS, and if there's anything included on these disclosures that doesn't sit right with you as a buyer, you can walk away from the escrow and from the home and get your earnest money deposit back. So last week we had real estate attorney Jonathan Black on to give us a deeper understanding of the documents and what to expect to find out about the property during that contingency period. If you haven't watched that video yet, I definitely suggest pausing this one and heading there first. Laura is going to piggyback off of that conversation and, like Alyssa said, tell us what happens next. But before we do so, Jonathan gave us a few funny stories from his experience and time as a real estate attorney, and we were hoping we could hear one from you and your mediations in the past.
Absolutely. Happy to share a funny story. It's actually a story from your area. What had happened is there was a property that had gone into foreclosure and it remained vacant for many years. Well, it had actually turned into kind of people broke into the house and were partying in the house. And there was this young kid who was about 19 years old. He weighed about 110 pounds. He went to the house and actually he got killed and buried in the backyard.
Oh,
and so, yeah. And so he was there for about 6 months. And the cops came, they, excavated the body and, basically the bank came in, cleaned everything up with the house. And a couple of years after that, they went and hired a real estate broker who was new to the area. She didn't know anything about this story. And so she lists the property and finds this great buyer who says, hey, it's a perfect house for us. They were from China. And Chinese, they have very strict rules about what they can have and what they can't in their homes. And so when the buyers moved in, the neighbor came over and said, well, how did you feel about that body that was buried in the backyard? And the buyers just walked away. They just grabbed their personal belongings they had in hand, left the stuff that they had moved in the house. And so it had erupted into this big dispute. But the buyers came to us and actually we were able to go back to the bank and the bank repurchased the property back from the buyers. Yeah. So I've seen everything, every kind of case you can imagine.
I can't right now. That story is
I just have the chills.
Where was this, Laura?
Oh, it was in the San Diego area. I don't know San Diego very well, but I know the property was down there. And the reason I knew the weight of the kid was because I actually saw a copy of the autopsy report. So, yeah.
Crazy. But these things, unfortunately, happen. And stuff comes up after close. I've sent you quite a few issues that I've had with, something that was left out. And then we call a contractor and they go, oh, actually, we've been to that house before. So we find out that they for sure knew about it and they didn't disclose something. So what is, if you discover something after close that should have been disclosed, like somebody being buried in the backyard, what's your next step? What do you do?
Well, let's talk, that's why our services are here. real estate risk management, we provide services to brokers and agents and buyers and sellers to try to keep everyone legally healthy and out of court. I've been in this business since 1995, and mediation has actually become my passion. In addition to handling real estate mediations and being the COO of my company, I actually volunteer my time at the Sacramento County Superior Court, where I work as a mediator in the civil division where people are trying to get restraining orders against each other. So mediation is a really big passion of mine, and when there's disputes after the close of escrow, I love to jump in the middle of them. It's like a big puzzle to me, and I'm trying to put all the pieces together. So it is definitely a passion of mine, and a lot of people don't know what mediation is. And so I'd like to take a few minutes just to talk a little about what mediation is, what can happen in mediation, and then answer any questions that you might have.
Please do.
Okay, great. So first, what is mediation? A lot of people think that mediators, you know, they're judges, they can make determinations. That's not what a mediator is. Mediation is a confidential, non-binding process in which a trained mediator acts as a neutral person who facilitates communication between the disputants and assists parties in reaching a mutual acceptable resolution to part of their dispute or all of the dispute. Mediator is a non-decision maker, meaning we can't rule like an arbitrator can or a judge can. The parties in mediation have the opportunity to describe the issues, discuss their interests, their understandings and feelings, provide each other with information, and explore ideas for the resolution of the dispute. A mediator is often able to be, to more fully explore the parties' underlying interests, needs, and priorities. Mediation is flexible and less formal process and may reduce the time and costs associated with a formal trial. Speaking of that, let's talk a little bit about what are the costs associated with formal trials and other legal platforms. The short answer is money. Legal proceedings can cost a lot of money, especially if you hire an attorney. Let me give you an example of a case that I know about. So you had a $25,000 dispute. They went out and they hired an attorney who, of course, charged them a retainer because attorneys don't work for free. The attorney started working on the case, and the filing fees came to $1,500. His time came to another $1,500. They'd give him a $5,000 deposit.
You're more than your $25,000 at this point.
Exactly. And so the attorney started working on the case and kept asking them, replenish the retainer, to the tune of $29,000 it cost them to go to trial and have this heard. They were not awarded recovery of their legal fees and court costs. Mm-hmm. So they ended up paying $29,000 for the legal fees and court costs. Then they ended up paying additional funds to try to collect the $25,000 judgment from the other side. So legal is very, very costly. And when you're involved in a lawsuit, it's the first thing that you think about when you wake up in the morning, and it's the last thing that you think about when you go to bed at night, which is why I have such a passion for mediation and helping people get these situations resolved so they don't have to go out and spend all this money. With mediation, you can have an attorney or you don't have to have an attorney. Most of the time on the cases that we work with, people want to represent themselves because they don't want to be more out of pocket.
That makes sense. Why don't you touch on the mediation and arbitration clause that's in our purchase contract and kind of what that means when people are agreeing to it?
Okay, great. Well, the mediation clause used to be optional, used to be able to initial next to the mediation clause. That is not anymore. If you enter into a purchase agreement, the mediation is automatic, which I think is great, which means that the parties have, if there is a dispute involving the property, they have to go to mediation. Now, mediation can run for formal mediation settings. That can run anywhere from $2,000 to $3,000 for just a half a day session. And it's really dependent on the type of mediator that you pick. But let's just say for round figures, it's $3,000, which means each party has to pay their portion of that mediator's time. Now, as I said in the beginning, mediation is non-binding, meaning there's no judge, there's no determinator in the situation. So you can go into an all-day mediation and go back and forth, and if at the end, one of the parties doesn't like how things are going, they can just say, forget it, I'm walking away. Then the next step would be moving it into arbitration if that is what they checked. Now, an arbitrator, different from a mediator, they're the decision makers. So they get the case, they meet with the parties, and there is a decision made. Now, arbitration cannot be appealed. That's it, it's over, it's done. So it's, it's, in my opinion, I've worked for arbitrators, and I've seen that sometimes an arbitrator can have a bad morning. They got stuck in traffic, their kids are calling them, they're having a bad day, and it rolls into the case. And that to me was always very scary because it's one person, their legal background, going by the law, and making that decision. So, and arbitration is actually 2 to 3 times more expensive than mediation.
And you had mentioned in the last case that they don't always recover those fees. So they might grant you, that you won the case, but they may not say that you can recover your legal fees. I feel like people always assume that if they're in the right, they're going to get those fees covered for themselves.
Absolutely. And, I don't see a lot of cases where legal fees get recovered. Even if they're wrongly named in a case, I don't see that, people get those legal fees back very often.
Wow, that's interesting.
So Laura, how does the process work? If a buyer comes to us and says, hey, we just purchased this home, this is going on, we think the seller should have disclosed this, what's the first step?
The first step is to contact RERM's Legal Service Center to speak with one of our mediators. What we do is, first we talk to your client. We find out what is the problem, why they feel the other side is responsible, and what is it going to take to fix it. So getting estimates from licensed, bonded, and insured contractors. Let's say I had a case, let me give you an example of a case that we worked on. We had a case where the seller lived in the property for 15 years. They were represented by the same agent, and they closed escrow. The buyer decides to start remodeling, and they pull down the sheetrock and they pull away the insulation, and there are burnt beams throughout half of the house.
Oh,
none of this was disclosed. Yes.
Nightmare.
So none of this was disclosed to the buyer. So on the burnt beams was actual wire, and on the wiring and insulation, there was information that led the buyers to find out the date, and the date on that wiring and insulation was 5 years after the sellers had purchased the property. So the buyers came to us. We talked with them, and they said, we have gotten the documentation to prove that this was put up and, went during their ownership. We said, okay, fine. So we helped the buyer. Now, we can't write a letter for a buyer. That's a legal act. But we can help them write a letter. We give them examples and things like that.
And I've
so they communicated over.
Yeah, we've helped our buyers to write the letters as well.
Mm-hmm.
Yeah. So they write the letter to the seller, and the seller responds back, we don't know what you're talking about. So RERM's mediators, actually I was the mediator on the case, I reached out to the seller and I said, okay, you can mediate with us at no additional charge. So there's no fee for you utilizing RERM's team of mediators to your client or to any of the other parties. So instead of paying that $3,000 fee, you can utilize our services, and they're unlimited to your clients. So we stepped in and we started working with the seller in this situation. They agreed to work with us, and actually we were able to come up with a complete agreement They did agree to pay for all of the repairs because we talked about, okay, if you go on to, a formal setting in mediation and arbitration, it's going to cost you thousands and thousands of dollars. And so the seller said, no, okay, we're going to pay to fix it. And they paid to fix it, and all the repairs were done, and everybody, after about 3 months, walked away happy.
Oh, that's amazing.
Yeah, geez, Louise.
But we want to scare people out of, buying a house, but ultimately,
Every time.
I have been, luckily we have the services of RERM on every transaction we do, and I've had so many of these, and ultimately most issues are small. We're able to write a letter with the assistance of RERM. We help you write the letter, and we can usually get them resolved fairly easily. So we just want to kind of let people know that these are out of the norm. They don't happen frequently, and they are usually easily resolved as long as you have a team behind you that will continue to fight for you after they get their paycheck, basically, because a lot of people, once they get paid, they're gone, and you can't really get anyone to help you afterwards.
Absolutely.
How could a first-time homebuyer minimize their risk as much as possible to not run into these situations?
Oh, that is a really great question. I'm glad you asked that, because we deal with a lot of first-time buyers. And basically, buyers fall in love. They see first-time home buyers. I remember the first time buying my house, you fall in love with the house, and you don't really know what you're supposed to be looking for and things like that. But because this is the biggest investment in their life, the best thing they can do is understand you need to have the inspections done. You need to really look over the disclosures. You need to really go out there and have the home inspection, the roof inspection. Ask the seller for the insurance claims that have been filed on the property. Because they can get that from their insurance company, or they can get it through a LexisNexis report. Making sure that it's the right area for them. I've just seen a lot of cases where people are just so in love with the house, they want to go from zero to purchase, and not really take the time to really study and understand everything about it. And get the disclosures, go over the disclosures. And I know you go over all of the disclosures really well with your clients. And in the case that if something isn't disclosed, that's why our services are here.
Awesome.
So 2 questions for you. One, during escrow, when you're doing all of this due diligence, how can RERM assist if, a buyer has a question or a seller has something that they're, hinting to, but won't give us too much information, or there's just a discrepancy in general? What can you guys do to help?
Oh, that is a great question. I'm glad you asked it. We provide transactional, non-dispute legal consultations for your clients to speak with a real estate attorney or tax attorney or water rights attorney, whatever area of law it falls into in regards to buying the property. They're going to get a half-an-hour consult with the attorney, 10 pages of document review, and they can use this service unlimited before and during escrow. All they have to do is enter into a representation agreement with you, and they can get all of their transactional legal questions answered. And there's no upfront fee for this service. It's just part of working with you as their brokers and agents. These consults are unlimited, 1 consult per subject matter, but unlimited subjects. And these are valued at $350 per consult.
Awesome.
I would even say they're valued at more than that, because I've used this countless times, because we can't give, and no agent should be giving you legal advice ever. So if you have an agent that's trying to advise you on your tax implications, or trying to advise you on what it means to accept any type of risk in terms of disclosure, they shouldn't be doing that. They're not attorneys. So we love having you guys as a resource to be able to give our clients actual legal advice.
Absolutely.
Absolutely.
So going off of that, what would you say are the most common avoidable pitfalls that a buyer runs into?
The big, let's probably the biggest thing is when they are rushing through things. Example, I had an agent who was actually buying her own home and representing herself. And she was signing the disclosures, e-sign, on her cell phone. She didn't even read them. They were signed because they were e-signed. We had the time stamp on them. It was like 4 minutes she signed these. And so there was a disclosure on there about a plumbing problem and to have it investigated by a professional. She didn't do it. She closed escrow. She moved in and the plumbing was shot. She had to replace it, but that had been disclosed to her. So in our opinion, it's, you know, take the time, do your due diligence, explain to your agents exactly what you want, what you don't want, and just take time and really, you know, as this is the biggest investment of their life, they want to be happy and they want to make sure it's everything that they need.
I love that. And I think that's so important that buyers need to take it upon themselves to investigate these properties, because a lot of times they just don't understand the importance of it.
Yeah. Also a comment just off of that, and you mentioned the inspections multiple times. That's something that's so important, especially as, you know, a first-time homebuyer that doesn't have the experience. We understand that it costs, you know, a few $100s to get some of these inspections, but a couple $100s is so much better than thousands and thousands of dollars down the line, because you just didn't want to check it out in the beginning and make that, you know, purchase.
Absolutely. I've seen so many cases come to us where they waived all their inspections and I just love the house. I just love the house. And it's like, okay, we understand you love the house, but this is your big investment in life. So make sure you're doing everything to make sure it's the right fit for you.
Perfect. I think that's great advice. So just kind of going back, so we use your services for mediation. If people can't come to an agreement, then what's next per that mediation and arbitration clause?
Okay, that's going to fall wherever the dollar amount is. So if in California, small claims court is up to $10,000. So if the matter falls within the jurisdiction of small claims court, that is an exclusion from the mediation arbitration provision in the purchase agreement. It doesn't mean you don't have to go to mediation. If it's a small claims court matter, I highly recommend they use mediation, because in small claims court, sometimes it's coin toss. You never know which way it's going to go. Where with mediation, if we can work with the parties and get it settled so you don't have to go to court, you don't have to go try to collect a judgment. Because just because you win in court doesn't automatically mean that person's writing you a check that day. You could have to go after them in collections and they could file bankruptcy and then you end up with nothing. So in the purchase agreement where it talks about dispute resolution, if it's small claims court, probate, small claims, and bankruptcy court are excluded in that provision. But if they do sign the arbitration provision and the matter is over $10,000 and you did offer mediation and it didn't resolve it, or the other side refused to mediate, the next step would be arbitration. Or if the arbitration provision wasn't signed, they are free to go forward with the court.
Okay.
So then, okay, perfect. Did you have any other questions on that, Nicole?
Nope, that answers my question.
And then the arbitration would be binding, correct? Once you do go to arbitration?
Correct. Correct. It's the decision is made that day, or if it takes a couple of days.
Would you advise your clients to sign that arbitration agreement in the RPA?
It's a personal decision. It's much more cost effective to go to arbitration. I will tell you that, compared to, you know, the $29,000 going to court. Arbitration, you know, could run $6,000 for the arbitrator's time.
Okay, cool.
So just something to note, and I'm hoping you will agree with me on this one. But, you know, as agents, we always keep our files of all of the paperwork that comes through and try to be as organized as possible. But would you recommend to buyers that it's very important that they keep a record of everything that goes on through the transaction as well, so that if something was to happen, they would be prepared with the documents to support whatever argument that they have.
Absolutely. 100% I agree with you. You know, buyers, they've got to, I can't tell you how many cases have come to me where the buyers are like, well, I had this, but I can't find it. And it's like, okay, well, let's go to your agent. The agent says it was never sent to me. You know, so it is vital that they keep all the records. Just like you keep your deed of trust to your home, you keep all your real estate records. I bought my house 4 years ago, and I still have all of the paperwork.
Yeah. And just to know, as a buyer, even if you don't ever run into any issue afterwards, it's just, you know, it's better to have for when you go to sell too. You have more to provide the next buyer, and you really, you know, what were you going to say?
Oh, it keeps you protected.
Exactly. That was my whole point.
Absolutely. I would recommend, if you're selling a house, that I show the buyer your disclosures that the seller gave you.
Exactly.
100%. Cool. Well, is there anything else that you want to touch on, Laura, that we haven't covered?
Well, let's see. Why don't we talk a little bit about a percentage of how many cases go to have disputes after the close of escrow?
Yeah, to kind of ease people's fears on buying, because it's a little scary when you hear about all of this.
I know. I'm the Grim Reaper. I've got all the scary stories. It's about 12% of the time according to our records. It's about 12% of the time. Now that can be something simple. It can be a dispute like a barking dog next door that won't be quiet. And our team of mediators, we mediate anything affecting the property. So it can be a non-disclosed issue by the seller. It could be a problem with a third-party contractor like the termite company, licensed contractor that came in and did repairs, but the repairs aren't working. The roof is leaking. We've had a lot of cases where, you know, the roofer will certify, oh yeah, it's 10 years, it's going to be great. And then the rain comes and the house starts leaking. Our team of mediators will step in, and even though there is no mediation clause between the buyer and the roofer, that doesn't stop us from offering mediation to try to get the situation worked out. And that is for the lifetime of the transaction. So as long as the buyer lives in the house and as long as the seller has sold the house, they are going to have lifetime mediation services through RERM.
Amazing. I can't tell you guys how invaluable RERM services have been to myself, and I'm sure I can speak for Nicole as well. In the beginning of my career, one of my first sales was a flip, and the driveway started chipping up in pieces. And so I had to go back and dig and call the product and create this whole legal file to try to get my client the money back for their driveway falling apart. And if I would have had RERM, it would have saved me hours and hours of time on having to go after that one issue and try to mediate it with the seller of that property. So how do buyers get access to your services?
Number one, when they close escrow, we send them a certificate of benefits. So that way they have it, and we always advise, hey, keep this with your important documents, keep this with your real estate documents. And then they can call us on our 800 number, which is 1-800-937-6526. We handle any dispute after the close of escrow. Before the close of escrow, they get all of their legal questions answered, one consult per subject matter, but unlimited subjects. And if escrow doesn't close, there's no fee.
And you have to use one of the agents who has paid, you know, to be a part of your...
Oh yeah, absolutely, absolutely. This is not a service that everyone has. It is an exclusive service, like through your office. Your office has this on all of their transactions. So this is not a service that all the other real estate companies out there have. It's basically, we really screen our real estate brokers and agents to make sure that they're going to be a good fit for our services.
Absolutely.
And you two definitely are in your office.
Well, thank you so much. And it's been, like I said, it has just changed the game once we brought you guys on. And the fee for our clients who we sign up to them is $124 that you have to pay to be a part of it. And if you are a buyer and you want to buy and you want this service and you mention this video, Nicole or myself will actually cover that fee for you. That way you get access to RERM and all of these benefits for free.
Use the code Blondes Breakdown Real Estate.
Yes. But if you're an agent and you want access to RERM, feel free to reach out to Laura. She can evaluate and sign you up if you're a good fit, and then you can give your clients access to this service.
Absolutely. And if there's any additional questions, we're really user-friendly. Call us at 1-800-937-6526, and we'll be happy to answer any questions that you might have about the service. And, you know, it's really great to have been a part of your podcast today. Thank you so much for having me. And everybody out there, stay healthy and safe.
You
Thanks,
too. Thanks so
All
much.
right. Be
Bye.
sure to like, comment, share, follow, and we will see you on the next video. Thank you.
See ya.
Thanks so much.